Hello, and welcome to this Bartfeld's Forensic Accountants webinar on confiscation cases in lockdown. My name is David Winch. I'm a chartered accountant and a director of Bartfeld's Forensic Accountants. And my particular interest and speciality is in crime and proceeds of crime. I find that more interesting than some of the civil cases that my colleagues deal with. Today, I want to talk to you about confiscation cases and the implications of lockdown on timetables and deadlines that we have to deal with in confiscation. I think it would be useful if I can show you some slides while we're doing that. And here's the agenda. So we're going to start by talking about the court deadlines, what they are, and where they derive from. Then we talk about extending those deadlines. Then we move on to perhaps the more interesting bit, which is what happens, what are the implications if something has gone wrong and deadlines have been missed or not set in the first place. Then we'll have a few words about other lockdown confiscation problems and how we can help. And if we've time at the end, we will deal with some questions and answers. So, court deadlines. As I'm sure you know, the court, and we're talking here about the Crown Court in England and Wales, where it's acting under the Proceeds of Crime Act 2002, Part 2, dealing with confiscation there. The court will normally set a timetable for the various steps. The first step is for the defendant to file a Section 18 statement. In effect, he will have received a list of questions prepared by the prosecution concerning his financial affairs, both current and particularly if his is a criminal lifestyle case, going back over a number of years. He'll be asked for information and will supply that under Section 18. The prosecution will then respond with a Section 16 statement, and that's the sometimes fairly bulky statement in which the prosecution set out their assertions regarding the defendant's benefit and his available amount. The defendant is invited to file a response to that under Section 17, and all these things happen before we get to the stage of the confiscation hearing. Now, you will notice that there's nothing in that timetable regarding a forensic accountant's report. So where do we fit in? Well, typically what happens is that once the defendant and his solicitors have received the Section 16 statement from the prosecution, with the prosecution's assertions as to the benefit figure, which might be fairly substantial, and the defendant's available amount, they will then contact us and ask us to review and examine that Section 16 statement to see if, on the one hand, literally it adds up, and on the other hand, if there are duplications or other errors in the Section 16 statement, or if there are other ways in which we feel that evidence should be put before the court, which might challenge those assertions regarding benefit and available amount. So we get involved pretty much alongside the defendant filing his Section 17 response before we get to the final confiscation hearing. And very often we are asked to attend the confiscation hearing and perhaps give evidence if it's going to be a contested hearing. So the court has set all these timetables. But in practice, it is commonplace for the deadlines to slip and for the dates to be rescheduled. But there is one of these dates which is much the most important, and that is the date of the confiscation hearing itself. When confiscation first came into English law in the 1980s, it was thought that in many cases a confiscation order might be made by the court on the day of sentencing. It was thought that this was going to be perhaps a quite straightforward exercise to specify the defendant's benefit and his available amount and make a confiscation order there and then move on to the rest of the sentencing, possibly a period of imprisonment or whatever. It soon became clear that life was not that simple, and that the confiscation proceedings involved some investigation into the financial affairs of the defendant, which probably had not been necessary in the course of the trial. So provisions were introduced to allow the confiscation to be postponed after the day of sentencing. And now Section 14 in the Proceeds of Crime Act 2002 deals with that, and it provides that the court can postpone confiscation for a specified period. What we mean here is that the postponement has to be to a date. We can't simply have the court say, we'll deal with postponement when we get round to it. There has to be a date specified. Let's say, for example, that the court postpones confiscation to a date no later than 31st of October 2020. What that means is that the confiscation hearing should be no later than that date, unless the postponement is extended. And it can be extended without undue formality if the application to extend is made before that period has expired. So if before 31st of October, the prosecution or the defence come to the court and say, we need more time, can you put that deadline back? Then there's no difficulty with doing that. As I mentioned, either the prosecution or the defendant can apply for an extension. And indeed, the court can extend out of its own motion. There's no need for a great formality with that. And that's something that we may see happening a lot as a result of lockdown. But there is a deadline. And the statutory deadline in Section 14 is that the confiscation hearing is to be held not more than 2 years after the date of conviction. And note here, we are saying the date of conviction, not the date of sentencing, which might have been a little while later. So the deadline is 2 years from the date of the defendant's conviction, unless the court finds exceptional circumstances, as Section 14 puts it. And if the court finds exceptional circumstances, then effectively that 2-year deadline disappears and there's no new deadline. So what do we mean by exceptional circumstances? Well, in practice, exceptional circumstances are fairly easy to find. For example, a fairly routine listing congestion could amount to exceptional circumstances. So this doesn't set a very high bar at all. Of course, in a pandemic, we've almost by definition got exceptional circumstances at the moment. So I don't imagine courts will have any difficulty in finding that the 2-year deadline can be done away with. But what about when things go wrong? The reality is that deadlines may not have been properly set, or the hearing deadline might have been inadvertently missed. So there are all sorts of ways where there can be some sort of mistake or omission which has resulted in this procedure not being complied with fully. What are the implications of that for the confiscation proceedings? Are they dead in the water, or are they, or do they survive that sort of mistake? Well, section 14 was amended by the introduction of subsection 11 to allow a get out in many cases. And that was a consequence of a number of cases coming to court where deadlines had been missed for one reason or another, and it was argued that the confiscation order then could not be made. Well, subsection 1411 says this: a confiscation order must not be quashed only on the ground that there was a defect or omission in the procedure connected with the application for or the granting of a postponement. So in effect, this seems to say if things go wrong, it doesn't matter. But as usual, things are not quite as straightforward as they appear at first glance, because subsection 11 is subject to subsection 12. And subsection 12 says, in effect, that if the court has already fined the defendant as part of the sentencing process, or has done some other act of forfeiture which affects his assets and which in effect would interfere with the confiscation process, then if that's happened already, subsection 11 cannot be applied. So on the face of it, we do then have a problem. But case law goes a little bit further. Case law indicates to us that unless the defendant has suffered some incurable unfairness, the court can nevertheless proceed to make a proportionate confiscation order. And there was a case there in the Supreme Court in 2016. What this means is that the courts view this particular deadline rather in the same way that a parent might view a deadline that he sets for his son or daughter to come home after a party. If I say to my daughter, I want you back here by 11 o'clock tonight, if she turns up actually at 5 past 11 o'clock, do I say to her, that's it, you can't come in the house, you are no longer my daughter, it's finished? No, of course I don't. I might give her a bit of a ticking off for being late, but I'm not going to disown her completely. And similarly, if there is a failing with regard to the postponement, some sort of missed deadline or some sort of failure to consider, for example, a failure to consider if there have indeed been exceptional circumstances, then that doesn't write off the whole confiscation proceedings. What the Supreme Court was saying, in effect, is, okay, subsection 11 would have allowed a get out where a deadline's been missed. But where subsection 11 is disapplied, it doesn't follow that there is no get out. What it follows is that we have to now look and see what has happened. Has it caused some sort of unfairness to the defendant? And if it's not caused any unfairness to the defendant, then what's the problem? We should just carry on. If it has caused an unfairness to the defendant, is that unfairness something that we can deal with some other way and so proceed to make a proportionate confiscation order? Or is the situation one where there has been now an incurable unfairness? So how might we cure an unfairness which has occurred? Well, an unfairness might be cured, for example, by allowing the defendant further time to prepare, so that he's not suddenly surprised by a confiscation hearing date looming up which he wasn't expecting. Or it's possible that in particular circumstances, a less severe order might be proportionate as a result of what has happened. But when making a confiscation order, a court has very little room for discretion. When we come back to the second webinar and we talk about what happens after the confiscation order has been made, but before it's been fully paid, we'll talk about a different section in which the court has a little more discretion as to what it's going to do. But at the moment, we're talking about the making of a confiscation order under Section 6, and the court really has very little discretion there. We've talked about what's proportionate, and subsection 5 of Section 6 requires that the amount required to be paid under the confiscation order should be proportionate. And there's another Supreme Court case dealing with what we mean by a proportionate confiscation order. But one point to note here, we are talking about the amount required to be paid, which has to be proportionate. We are not talking about the benefit figure having to be proportionate. And that can be an important difference. What we're saying is that there may be circumstances where the court arrives at a benefit figure, arrives at an available amount, decides which of those is the lower figure. Well, that's a fairly easy sum, don't need an accountant there. But then decides that making an order in that lower figure would not be proportionate. So it makes a smaller order. So the smaller order there is less than the benefit and less than the available amount. But let's suppose there has been some incurable unfairness. Suppose the defendant had thought that the confiscation proceedings had just gone away. And as a result of that, he's, let's say, started a new business and plowed a lot of funds into that. Then that could cause him all sorts of problems when the confiscation proceedings are resurrected. So, if the making of any confiscation order would result in incurable unfairness, and a hearing deadline has been missed, so that there has been some problem with the postponements, then the court may decline to make a confiscation order at all. But such a decision would be open to appeal to the Court of Appeal. Let's quickly have a look at some other lockdown issues. There are obvious problems with online hearings. Mentions may present fewer difficulties, simply because we've got less people involved. Aside from that, there can be difficulties in getting instructions from the client before the day of the hearing, particularly where the client is in prison. There's also a potential difficulty in having private consultations on the day of the hearing. And finally, there's a very significant risk of difficulty in the defendant realizing assets quickly at sensible prices in order to settle the confiscation order. Now again, that's something that we will be looking at next week. So how can we at Bartfield's help? Well, Bartfield's Forensic Accountants remains fully staffed. We undertake legally aided and privately funded criminal and civil forensic accountancy work. It's relatively easy for us, we're perhaps quite lucky in this respect, to conduct the bulk of our work remotely, using up-to-date and secure IT facilities. And we remain readily contactable by phone, by email, and online video links. Our recently updated website is full of useful information, and of course that's accessible 24/7. And in relation to this topic, you can find an article on our website at www.bartfieldsforensic.co.uk, Insights News. Also, you will receive a free recording of this webinar, which will be emailed to you. Okay, let's deal with a couple of questions that have been put while we've been doing this. One question is it easy to get legal aid for a forensic accountant's report in relation to confiscation? And the short answer is yes. We've never experienced any difficulty, or the solicitors instructing us have never experienced difficulty in getting legal aid for a forensic accountant in a confiscation case. Don't forget that the prosecution are using a financial investigator who has some experience, at least, of accounts and financial matters. And the solicitor and counsel may have less experience of that. So you need somebody to give you equality of arms. And that's certainly something that we can help with. What normally happens is that the solicitor is required to obtain perhaps 2 quotes from different firms of forensic accountants. And the legal aid agency, I'm afraid, don't look to the quality of the firms, they simply look to the price. And whichever is the cheaper quote is the one that they will approve. But that's life. Next question is, do I see confiscation hearings going ahead during the lockdown? Well, I think the answer to this is we have to wait and see. Crown courts, I know, are trying to find ways to deal with hearings online. Certainly, as far as administrative matters are concerned, they're making some progress. There is talk of doing sentencings online. And an issue there, of course, is that the sentencing has to be a matter of public record. It has to be open to the public. And so there needs to be a way of dealing with that if the sentencing is being done remotely. But yes, confiscations in general are settled by some negotiation. Very often the case is that the 2 sides will have some serious discussions and then will eventually come up with some sort of agreed figures which can be put before the judge for his approval. But if you have a contested confiscation hearing, then it may well be that the only witnesses apart from the defendant are people who are well experienced in giving evidence in Crown Court. So you've got perhaps the FI who wrote the Section 16 statement and possibly a forensic accountant such as myself as the only witnesses apart from the defendant. So it isn't too difficult to do those sort of things online, I would suggest. And I think we are going to see that happening over the next few weeks. So finally, there's our contact details. We will be back next Wednesday at the same time, dealing with, as I've mentioned, the period between the making of the confiscation order and the final payment of it. And we'll be talking then, of course, about Section 23. I look forward to see you then. Thank you very much for your time.